good afternoon and welcome to our session today for the Leasehold Knowledge Week. We are going to be discussing mediation, preparing for life post-lockdown, what you can do with a dispute without going to court this afternoon. A very quick thank you to our sponsors, BBIS Commercial Heating, JPC, Towergate Insurance Brokers, PLP Fire Protection, Foresight, Realty Law, Blackguard Insurance, Chandler Harris and Pearlygate Maintenance. Now, today's presenter is Roger Levitt. Roger was a founding partner in a leading West End law firm in the 1980s, and he practiced as a commercial property solicitor for 35 years. He trained as a mediator in 2009 and became a full-time mediator in 2018. He is a leading mediator of the Lead 500, having conducted over 125 mediations in all types of property and commercial disputes, both online and face-to-face. He is a member of the Civil Mediation Council Registration and Standards Committee on a number of panels, including RICS and the PLA panel of Boundary Dispute Mediators, and a non-exec director in a London law firm. Now, Roger is going to be happy to take any questions. So as the presentation unfolds, please pop any questions you may have using the Q&A button at the bottom of the screen. And at the end of the session, Roger will aim to answer as many as he can. So Roger, hello, how are you today?
Yeah, very good, thank you. Lovely to be here. Lovely to be here where I've been for the last year. And it's great.
I know.
Great way of working though. This is really good. So thank you very much for inviting me.
Lovely. Well, I'm going to hand straight over to you. I'm going to turn my camera off and hand the floor over to you.
Thank you. So welcome everybody, and because I can't see you, I don't know how many of you are familiar with mediation and how many of you are not, but we'll soon find that out by the sort of questions that you ask. Feel free to direct any questions in the chat, and Charlotte will pick those up and I will happily answer them at the end. We all found ourselves 1 year ago today, quite remarkably, in a lockdown situation, and along with many of my fellow mediators, we suddenly realized that overnight we had to become experts in online dispute resolution. And whilst that was an immediate business need as far as we were concerned, it couldn't happen that quickly. And obviously we all had to learn and practice amongst ourselves to get to the point where we were ready to launch ourselves on onto real cases. And it's been a fascinating journey. I know everybody has their own tales to tell about how things have developed for them during the lockdown, but I have to say, a year on, it's presented for me and many of my colleagues a tremendous opportunity and not a threat. And the conclusion that I've come to is that the ways in which we're working online, the dynamics which have been brought about by working online, particularly in mediation, has actually been a big plus for mediation, because a year ago I wouldn't have had any idea that the ability to get people together online would be so much easier than getting people together face to face. And the idea of getting people to sit on a screen together, who more often than not would not sit opposite each other on a table, is just been a complete game changer. Because if you can get people to feel comfortable at home and to be able to open up and to talk about the particular dispute that they have, rather than feel that they've got to be anxious and nervous and hesitant about going into a building to, even if not sit face to face with someone, to be sitting in another part of the building and then be worried that they might have to face them when they go to the loo. So it's been a complete revelation, as far as I'm concerned, how things have changed and how quickly they've changed. And coinciding with this has been the change in the way that the courts have been able to deal with disputes. Now, clearly, there are some courts who are able to deal with priority issues online, but the courts were struggling before the lockdown, and the impression I get from talking to many litigators is that things have only got worse. So the purpose of our discussion today is to try and work out what we can all do to help resolve a property dispute without going to court. Preparation is absolute key, and it's so important that I'm coming back to it on a later slide. But this is a famous saying by Benjamin Franklin: by failing to prepare, you're preparing to fail. But I do find that this is something that is not given enough attention generally in mediation, and I think it's really important to prepare well in advance. I have a briefing note which I send out when I'm instructed, and it sets out in great detail what to expect, what not to expect, questions I like to be answered, and generally it hopefully puts people in the right frame of mind for resolving a dispute in a collaborative and non-adversarial way, because my training of 35 years as a commercial property solicitor was not geared at all to being confrontational. My aim from day one in a transaction was to get people around the table to do the deal. So I talk about setting the scene here, and I mentioned that already. It's not something that is quite as easy as it sometimes looks. We all, I believe, we all now familiar with Zoom and or Teams and any of the other platforms. But if you can cast your mind back a year, I suspect that most of us weren't, and therefore it was yeah, it was a little bit scary to start with. So I mentioned earlier about the courts, and obviously the courts have a huge part to play in dispute resolution. The importance of having access to justice is absolutely key. However, I'm finding more and more, I was finding more before the pandemic, and I'm finding more since the pandemic, that people are looking to mediation at a much earlier stage, probably as a result of several factors. Firstly, as I've already mentioned, that the court system has been struggling, and it's made people think. It's made solicitors think. It's made the judges think. How would it be possible to relieve some of the pressure on the courts to have disputes resolved in a way that can be satisfactory to the parties, and also to relieve the pressure on the system? Because, you know, there's no doubt that the system is definitely creaking. So I found in the 12 years that I've been mediating that there has been a shift in the attitude of the judges and dispute resolution solicitors towards working with mediation as part of the toolkit. It's almost a perfect storm, actually, having the pandemic, because it's focused everybody's minds on the fact that the courts couldn't really cope anyway. The courts now to cope during a COVID situation is just not realistic. So how easy is it to set up a mediation? Well, online, the process is much easier. There are far fewer barriers to the process actually being up. So whereas people used to find excuses about venue, whether it was that the venue wasn't neutral, or I'm not meeting on their, on their territory, or I'm not traveling to Manchester because that's not convenient for me. So now with everybody being based online, wherever they are, because they don't need to be at home, it could that they can pop in and be socially distanced in their solicitor's or barrister's office. It's much harder to say no, and so getting people on the same screen, as I mentioned earlier, is actually much easier. And once you've got people on the screen, the dynamics are very different. Because if you're relaxed at home, you're more likely to open up. You're more likely to talk. You're more likely to be conciliatory, and the proof of the pudding is actually that it has worked. We didn't know before we tried it that it would work as well, but actually the whole process is simpler. And I think given the choice which we will have when restrictions are lifted, I think that many people will still opt for online mediation. It's not, I don't see a situation where suddenly things are going to change back to the way they were before, because we can't put the genie back in the bottle. And whether it turns out to be a two-tier system or a parallel system, I think that the choice people will have, which realistically they didn't have before, because we all didn't know how to operate it as well. But I think the choice will make a huge difference. As Charlotte mentioned, I'm on the panel of the RICS PLA boundary mediators, and it's not a coincidence that during the pandemic I haven't had to do a boundary dispute. Now, whether even if that was not an attended boundary dispute, people have held back. With a boundary dispute, I believe you have to walk along the ditch, you have to walk along the boundary, and you have to do that with all the participants and the advisors, and clearly that hasn't been possible during the pandemic. But it will be interesting to see after the removal of the restrictions how that might change. So I mentioned previously about being prepared, and I said I'd come back to it. Preparation for me starts ideally 2+ weeks before the mediation, where I send out a briefing note which sets out in detail how the process works, what to expect, what not to expect, and I also ask a whole series of questions to try and draw out from people what the dispute is really about, because more often than not the dispute turns out not to be about what you're told it's about, if that makes sense. There is often something under the surface that people don't express. Sometimes they don't even know exactly what it is, but that is driving the dispute. And it could even be something, you know, as obscure as, yeah, my father used to be bullied by your father when they were younger, or something that is not immediately apparent. And so I think it's important to spend time before the mediation, getting to know the participants, understanding where they're coming from, obviously reading the documents and asking questions on those. And I find that this process is best started by a separate Zoom meeting, which I would have with each of the participants and their advisors, so that by the time the mediation itself starts, everybody's in the right frame of mind, and they're prepared for peace and not war. They're prepared to be constructive, they're prepared to be pragmatic, and they're prepared to go beyond their comfort zone and a bit more, because if you're not prepared to stretch yourself beyond what your negotiating position is, then usually it's not going to work. You know, if you come to negotiate just on your own terms, then you might as well not bother. Okay, so I touched on the pre-mediation Zoom meeting. It's still important to check the technology, because as we all know, things don't always work as we expect them to work. Most people are used to Zoom or Teams. I personally prefer to use Zoom, but not everybody is familiar with it. Not everybody is familiar with the use of the breakout rooms, and so you can test that with people in the pre-mediation Zoom meeting. You can explain to people about the body language. You can explain about the atmosphere and the dynamics, because again, some people won't have been or won't have had experience of a Zoom mediation before. And it's also very important to check the attendees. I've had Zoom mediations where people have been sitting out of camera, but quite clearly giving instructions to the person who's sitting in front of the camera, and it always comes out in the end. I don't know why people think that they would get away with it, but it's just not appropriate. If you it's absolutely essential that you're dealing with the people who have authority to settle the dispute, and that doesn't just mean they are authorized. It means that you understand and it's made clear the level of their authority. And many a meeting has been delayed because somebody has to contact somebody, not even off screen, but you know, in another part of the world, and they haven't disclosed that, which is hugely frustrating, because you know, it's one of the questions that I ask in the briefing note, but it just means that the process is going to be slowed down. So that, you know, that's obviously not from anybody's point of view advantageous. And as I said earlier, having the right mindset, which is absolutely key. It's extraordinary how many times people tell me in their position statements that they've come with all willingness to be sensible and commercial, and they're going to do the right thing by negotiating, and then when it actually happens in practice and they're in the meeting, they're not prepared to budge. So you know, that doesn't help the process. Okay, so having got the right mindset, and being prepared for settlement and not for litigation, I always think that it's very helpful and actually quite important in the closing stages of a mediation that the one or sometimes both of the solicitors have brought with them a draft skeleton settlement agreement with all the issues listed. It doesn't mean that you're tempting fate by doing that, because you wouldn't necessarily be putting the figures in. The figures can go in obviously at the last minute if and when they're agreed, but it does save a huge amount of time. And I've had mediations where we've got a settlement at 5 o'clock and we haven't got a signed settlement agreement until 8 o'clock. But it's just because people didn't come prepared. So for the future, well, as I mentioned earlier, I think we've all found a new way of working, and having crossed this Rubicon, I genuinely believe that we're not going to go back. From my own personal point of view, I found it's a hugely successful and rewarding and enjoyable way of working. The massive advantage of not having to travel, which obviously benefits all parties to the dispute resolution process, I think is so overwhelming. and I think, you know, I've talked to lots of people about this. I think that lots of people haven't really reflected on how much we found traveling was an inconvenience until the lockdown, when we didn't have to do it. But we took for granted that we would go anywhere around the country, and that was just because we had to do that. So I mediated in Scotland, and it took me six hours each way. I didn't do it in one day, but nevertheless, it was that was what we did. And I think now that we've found a different way of working, that we're going to have a different approach to travel. And you know, as I mentioned earlier, I think that a blended approach of online and offline is what will emerge. And I believe that that's for the good of the participants, the advisors, and the courts. So I'm more than happy to take questions if Charlotte has got any that have come through.
Hello, I do actually have a question for you. I have a question. If you have an open and shut case against a landlord or tenant, why should I mediate?
Thank you. That's an interesting question. What I would say in answer to that is that there's no such thing as an open and shut case. Even if you have what we would term as an open and shut case, it's very unlikely that it's going to be more than a 70% chance of success. And if you asked a barrister for an opinion and they gave you an 80 or 90% chance of success, then I would question that opinion. And so if we take a 70% chance of success, we've got a 30% chance of failure. And once you analyze the 30%, it makes you think more and more that is this a risk that I want to take? Yeah. Bearing in mind the fact that, you know, I don't know which judge will be presiding. Judges can can give opinions that we might not like, might not expect, and so I would say that the risk there is still great with the best case, and then of course we get into the situation of discussing the court's ability to actually process the case, as I raised earlier.
Okay, so I've got another question. You mentioned boundary disputes. Can you think of any other types of property disputes which are likely to benefit from an in-person mediation?
Well, because I do all types of property and commercial, but I'll concentrate here on property because that's our area. I would say that any property dispute which relates to development, construction, where it's essential to see the property in the same way as I would expect to go and visit the boundary. I would expect us to see the property in a construction related dispute, and that obviously also applies to dilapidations. So yes, of course, it's possible to get videos and photos, but it's not the same. It's not the same as walking around the site with everybody together and people being able to point out to you things that that they think are key.
Okay. Is it more cost effective to do mediation than it is to go to court?
Well, mediation is it's invariably cheaper. We have a practice in this country which seems to work, as far as I can see, comprehensively. That mediations are dealt with on the basis of a fixed fee. And so in my case, I would always include in the fixed fee the pre-mediation meeting. And so as long as it goes to time, people know exactly where they stand. There is always an overtime rate beyond a certain time, but I find that that's rarely used, because when people know that's the case, they work within the time allowed.
Is it a quicker process than going to court? So if you do mediation, is it a lot less involved than if you were going to court? Does that make sense?
Yeah, it's much less. So I think the quickest I've been instructed and conducted a mediation is in about 4 or 5 days, but that's not ideal, bearing in mind what I said earlier about preparation. But I would say that comfortably from standing start, 2 weeks to having a mediation in place gives you about a 75% chance of a successful settlement. And comparing that with going to court and not knowing how long the process is going to take, how much it's going to cost, one has to be careful not to compare mediation with going to court, because it's a completely different process. But if you want a resolution of a dispute where you can get a settlement that you could live with, then you can resolve. You can have that in 2 weeks if you're all working at it.
Okay. Another question. A recent mediation case required the leaseholders' complainants to sign a privacy contract to prevent the case being publicised in return for an additional settlement. Does this help to improve industry management agent standards if agents hide behind privacy clauses, which agents cannot do in FTT cases? Ooh. Interesting.
Yeah, that's a very interesting one, because obviously one of the strengths of mediation is that it's confidential, and that will invariably mean that when you get a settlement, you are committing yourself not to disclose any of the contents elsewhere. Now, there are two ways of looking at this. The first is that's really helpful because it gives people the freedom to negotiate, knowing that they've got the protection of confidentiality. But of course, the downside is, as the questioner mentioned, that you in bringing about confidentiality, you're not protecting the rest of the public. Mediation is voluntary, and so you don't have to submit to mediation if you don't wish to. You can participate in mediation and withdraw at any time. And so I think you've got to weigh up in each particular case whether this is something that is of public importance, in which case you either don't mediate, or you perhaps mediate with the ability to have a settlement that is can be made public.
Yeah.
But I appreciate that's really tricky when industry standards are being set, and the developers or landlords might be looking to
cover something up or keep something
come up with a settlement that they don't want to be made public.
So yeah. Okay. How early in a case do you think you need to make the decision that mediation should take place?
Well, I mentioned earlier that I'm experiencing mediations that are happening much earlier in the process, particularly or more so in the pandemic. That's driven by partly people appreciating that it just makes more sense before a dispute explodes. It's better to nip it in the bud. So common sense says save time, money, stress, and costs. But also there is a big incentive to issue, or not issue rather, or to mediate before issue, because you're going to be saving the issue fee. And if you've got a claim, for example, that's worth £200,000, a £10,000 issue fee is significant.
Oh no, absolutely. I think it is really tricky. I have one more question. How have you found during the pandemic? Have people embraced mediation? Have you found that it's become a lot more normal for people to go, actually, that's going to be my first route. I'm going to forget everything else. Let's just try that now.
Yes, I've found that people are more inclined to go for mediation and go for mediation earlier. I think part of this comes back to the way that we've all changed the way we live, and the way that we I don't know if it sounds a little bit corny. We are looking out for each other more during the pandemic, and generally people seem to be being nicer to each other, which is fantastic in terms of community and society. But it just seems to me that the old style aggressive litigation has it just isn't as popular.
I think, you know, as you say, people are trying their best to sort of get along and try and get things resolved quickly and quietly, without, you know, having to spend a lot of time and money going to court. So maybe it is a good route for most people. Oh, I have another question. You mentioned, we've mentioned boundary dispute. Can you think of other types of property disputes likely to benefit from an in-person mediation? What else would be good for an in-person mediation rather than just a boundary dispute?
Well, I answered that one earlier, and I said that anything that is development or construction related, I think as a property dispute would be something that I think it would benefit from an in-person mediation.
Right, press the wrong button.
That's right.
So, okay, well, I have got no more questions for you, Roger. Is there anything else that you would like to add at all, or anything else that you would like to share with the audience?
Well, as I haven't been able to see anybody, it would be nice to hear if from anybody out there, if any or all of what I've been saying rings true. Have people had experience along the lines that I've been discussing, or is it all new?
Well, you've been doing mediation for 10, 12 years now? And have you found that over the last, you know, when did you find that mediation was becoming really popular and a way forward?
I'd say in the last 2 or 3 years, but then through the pandemic, it's just escalated. And I suppose another question that I might have asked about what's going to happen in the future is the moratorium, which is protecting tenants from being evicted, will be coming to an end, and it's not extended. Will mean that tenants won't have that protection anymore. And it just seems to me, from talking to various solicitors and agents, that there could be an explosion of cases once that happens.
No, absolutely.
And that's obviously, you know, that's a concern, because the tenants have had protection up to that point, and you know, does that then mean that there will be an avalanche of cases? I mean, it's you know, dropping off a cliff can't be good at any point.
No, we had a conversation with one of our barristers from yesterday, and they did say that was the landlord and tenant disputes with eviction coming up soon is going to be really painful. They said that's not going to be good for anyone at all. So hey, no,
but then the court's going to have to somehow they're going to have to deal with that if that's the case. You know, obviously it's an opportunity for mediation as well. Only time will tell if that helps to alleviate some of the stark distress from you know, the tenant's point of view.
Absolutely. Well, Roger, I think we've done all our questions.
Wow.
Yeah, time flies. Thank you so much for giving the session. We will make sure that we send out your presentation to all of the people that have come into the session today, and of course your contact details. And if anybody wants to contact Roger, to do. Oh, I've had another question just come in quickly. In most disputes, an agent or the lawyer will try to negotiate a resolution to the problem. When this fails, one might turn to the courts. In lots of cases, we're told to consider ADR or pay the penalty with a costs order. Many clients become frustrated with the agent because they feel they've already tried that approach. Can we use the initial negotiations to display to the court that we have already tried to settle?
Part of the pre-action protocol requires that before you issue, you are able to show that you've tried some form of ADR, which commonly is treated as being mediation. If you're going to issue based on pre-negotiations, I would say that the argument is not as strong, because what most parties do now is that in order to cover themselves, they do actually offer mediation as part of the pre-action negotiations. So I think most agents are now very familiar with that. Obviously, the solicitors are, and it's, although as of now, it's not a compulsory step. It's a hugely expected step in the process of going to actually issue proceedings. Because in most cases, you will be able to find a solution, even if it's not on the day itself, in the days that follow. So I think the importance of the role of the independent mediator is a very important step, which the agent of each side can't perform because they're not independent.
Okay.
They can be great negotiators, and they may well be able to negotiate a solution, but they won't be independent.
Okay. All right. Well, thank you for that. Lovely. Well, that was an interesting one to finish on. Thank you so much for your time today. And as I said, we'll send out presentation and your contact details, etc. After the session. So thank you very much indeed. Lovely to speak to you.
Thank you. Thank you everyone for attending.
Thank you very much. And tomorrow we will be looking at the trials and tribulations of managing an RMT block, and we'll be looking at reading a lease. So thank you very much. We'll see you tomorrow. Bye-bye.